Clegg is leaving Meta. The U.S. Court of Appeals ruled against an effort to restore net neutrality. And Apple agreed to settle a 2019 Siri privacy lawsuit for $95 million. It's Friday, January 3rd, and this is Engadget News. Clegg, the former British Deputy Prime Minister turned Meta executive, is leaving after a 7-year stint with the social media company. Clegg announced his departure on social media, saying that this is the right time for me to move on from my role as President, Global Affairs at Meta. Clegg will be replaced by Joel Kaplan, a longtime policy executive and former White House aide to George W. Bush, known for his deep ties to Republican circles in Washington. As Chief Global Affairs Officer, Kaplan, as Semaphore notes, will be well-positioned to run interference for Meta as Donald Trump takes control of the White House. Clegg joined Meta in 2018, a year after the British public deemed the former leader of the Liberal Democrats unelectable. The company, then known as Facebook, was looking to improve its political relationships after Cambridge Analytica and other scandals. In 2022, he was promoted to President of Global Affairs, a position that reported directly to Mark Zuckerberg. The former politician played a key role in some of Meta's most significant and controversial decisions. He publicly defended the company's decision not to apply its fact-checking policies to politicians and authored its public statements about the suspension and reinstatement of Donald Trump's Facebook account. More recently, Clegg has criticized the European Union's handling of tech regulation, arguing that the bloc is hampering advancements in AI. Net neutrality may have hit its final roadblock. In a new decision filed this week, the Sixth Circuit U.S. Court of Appeals has ruled that the FCC does not have the statutory authority to implement net neutrality rules. The court first blocked the rules in August of last year when the lawsuit at the center of this week's ruling was filed. Net neutrality broadly seeks to prevent Internet service providers from giving preferential treatment to specific users or content. That prevents things like a service provider charging a streaming service for faster speeds or the throttling of a specific website. Every app, website, and user is supposed to be treated equally under net neutrality, making the rules integral to a free, fair, and open Internet. Since net neutrality rules were first put in place in 2015, the FCC's argument has been that its classification of ISPs as telecommunication services under Title II of the Communications Act of 1934 gives it broad authority to regulate them. The decision to redefine ISPs as information services during the first Trump administration led to the repeal of net neutrality in 2017. The current FCC voted to restore net neutrality on April 25th of last year, but the difference between 2015 and now is the Supreme Court's recent radical reinterpretation of an important legal doctrine. In June of last year, the Supreme Court filed 2 rulings that overturned the Chevron doctrine, a framework that basically said that if Congress does not weigh in on an issue, courts are supposed to defer to the interpretation of government agencies. Now, interpretation falls to the individual judge, and the Sixth Court does not agree with the FCC's argument. Net neutrality rules will remain in California and other states, but anything at the federal level will require either an act of Congress or, for this case, to be appealed to and succeed in front of the Supreme Court. Apple has moved to settle a 5-year-old class action lawsuit over Siri privacy. Reuters reported that the proposed settlement was filed on Tuesday in Oakland. The company agreed to pay $95 million to class members, estimated to be tens of millions of Siri-enabled device owners. U.S. District Judge Jeffrey White needs to approve the settlement before it becomes official. The lawsuit stemmed from a 2019 report that Apple quality control contractors could regularly hear sensitive info accidentally recorded by the voice assistant's Hey Siri feature. The clips were said to include medical information, criminal activities, and even sexual encounters. Reuters says Apple denied wrongdoing and agreeing to settle the case. Two plaintiffs claimed their inadvertently recorded mentions of Nike Air Jordans and Olive Garden restaurants led to receiving ads for those products. After talking about it with his doctor, another plaintiff said he got ads for a brand-name surgical treatment. After the original story broke 5+ years ago, Apple highlighted its layers of privacy protections and stressed that the recordings were not tied to Apple accounts. It also said its quality control teams studied the clips in secure facilities and were bound by strict confidentiality agreements. After an internal review, Apple suspended the program and admitted it wasn't fully living up to its ideals. The company returned to reviewing Siri recordings soon after, but with some big changes. It reportedly fired hundreds of quality control contractors and changed its policy so that only Apple employees could review private Siri data. It also moved to delete inadvertently triggered audio clips and began requiring users to opt in to sharing Siri recordings or transcripts. Thanks for listening. This episode featured journalism from Carissa Bell, Ian Carlos Campbell, and Will Shanklin, and was voiced and produced from the boutique sound studios of Spoken Layer. Enjoy your weekend, and I'll be back on Monday with more tech news from Engadget.